constitutes restatement of the law of American Indians, but that is not all. He is also the primary editor and author of the Turtle Talk blog, which is this authoritative source on current happenings in American Indian law and policy. He sits as the Chief Justice for the Porch Band of the Free Indian Supreme Court, and also sits as an appellate judge for numerous other tribal courts. He's been twice cited by the United States Supreme Court and more than a dozen times in federal, state, and tribal courts. His expertise in this field is nothing short of astonishing, and we're thrilled to have him as a keynote speaker. Without further ado, I'll turn it over to Professor Fletcher.
That's very, very kind and overly kind. I just gave a talk in front of my own tribe's community at our public museum, and my former boss started off by introducing me by saying, with no puffery or hyperbole whatsoever, I can say that Professor Fletcher has authored well over 200 articles, and now I know that's not true. Okay, I'm going to talk about the restatement of Indian, or as it's called currently, the restatement of the law of the American Indians. My lovely wife, when I was single, and I are the co-reporters, along with a good friend of ours named Kate Smith out of Maine, for this project. It's been ongoing since at least 2012, so it's been going on a long time, and we're a few years away from completion, assuming we get that far. I'm going to talk a little bit about what restatements are, what the process is like, and I'm going to do so in a way that hopefully is not ridiculously boring. It is an incredibly sober and important activity. So let me tell you my personal favorite story about this process. Years ago, we had an important piece. The very first time we had formal approval of a portion of the restatement, portions of Chapter 1, before the American Law Institute's Council. And they're kind of like the Illuminati of law. They sit in a dark room like this. There could not be more than 40 of them. I wish they would come in and put us with holding little candles. I'm sure that in their minds that that's what they're thinking they look like. And so afterward, they approved our sections, and they had a reception afterwards. And just, you know how you feel like you got a roller coaster or a bad airplane ride, and you're just elated with adrenaline, and you survived? We felt that way. And I was talking to a guy named Seth Waxman, who was the Solicitor General, and he was congratulating me on this. And it was just weird to be in this situation. And then he obviously was trying to get rid of me, so he passed me off to somebody else. This is about 3 or 4 years ago. And she was the general counsel for the Walt Disney Corporation, another of the Illuminati. And, you know, I don't know how to behave in these circumstances. So I said, Walt Disney, huh? I said, look, I got an 8-year-old at home right now learning my Spider-Man's not in the Avengers. And she says, I'm working on it. And now you know Spider-Man's in the Avengers. Because of her, because of me. All right. What I'm going to do is give you, it was great that the conversation this morning already has introduced a critical question in Indian law: who is or what is an Indian? So first thing I want to do is point you to the ALI website that has our restatement project on it. You have to be a member of ALI to look at all these documents. You have to get a password or pay money. ALI loves it when you pay money. But this is a list of the PDFs of all the drafts that we put together over the years. Yes, thank you for this. It's in reverse alphabetical order. We're currently on this. Actually, there's another draft after that one already, too.
Still going.
Drafts. Here's the bottom. January 2013 was the first time we turned in a preliminary draft. And there's a lot of it. A lot of the stuff is repeat with just edits, but they're all separate independent drafts. I have a stack of booklets that's this big now. This wide on my bookshelf. So that's just, the first draft we did was Chapter 1. Section 1 was, well, who is an Indian? The definition of Indian. Can you go to the first browser screen up there? This is from one of those very first sections, actually section 2. Actually, first section 1 was what is Indian law? Somebody asked us to put that in, and so we did. And that's all gone. This is the very first time I tried to define what an Indian was. And let's just say how the process works by looking at this section. Section 2, an Indian is a person who meets the statutory or common law definition of Indian. So yeah, question from the audience, isn't this kind of circular? Yes, it is. So we present this first. The first rough drafts of everything goes to something called the advisors. And the advisors were sort of like the true experts in the field. So I mentioned the Illuminati, the ALI Council. They're generalists. There's also the ALI membership. That's the collective group of, I think it's 4,000 people. They're maxed out at 4,000 who are lawyers. But the advisors, they don't actually have to be members of the ALI. But it's about 3 or 4 dozen people that I help select. About a third of them are supposed to be law professors, a third of them are supposed to be state or federal judges, and a third are supposed to be just practitioners. Loosely speaking, there's no hard and fast rule on that. So we got together a list of people that are kind of the obvious people. You know Judge Gandy, the author of the Nutshell, famous Nutshell. We got Evan Washburn, who was then dean at New Mexico, and then became assistant secretary, and then dean at Iowa. We got Angela Riley, who was at UCLA Law School. People that were willing and interested to show up to meetings and read through 100 pages of dense text and try to make sure that it's all correct. So, in a room now like this, first question on this, who is an Indian, isn't this kind of circular? Well, the answer to that is, of course it is. But how do you define Indian? And how do you do so in a way that is useful for purposes of the restatement? You'll see that this section here is a watermark. That's supposed to be black letter law. The law that is so encased in concrete that it cannot be undisturbed. It is so non-controversial that no one in their right mind would disagree that it is incorrect. It is the consensus of the vast majority, the great weight of authority, that this is what the law is. This is our first attempt, really, at trying to determine what black letter law was. And it's completely circular. So we got. Underneath the black letter are comments. Comments are descriptions that are helpful, that fix sometimes statements to a level that don't quite rise to the level of black letter law. There is some conflict. This is where we say aspects of this definition, for example, may have significant conflicts. So some courts may agree with this, some courts may disagree with this. A classic restatement provision will say something like, this is the majority of states, for example, adopt this common law rule. It's 30 states say yes, 20 states say no, and the restatement, the American Law Institute makes a statement that they choose the majority rule as the better rule. And we can explain that in the comments. So that's what we were trying to do in this context. I'm not going to ask you to read out this text. Can you move to the next section? So this is our next term. After we found out that it's not good to have black letter law that's straight up circular, try to add some flavor to it. And this goes on. You don't need to talk about this. Let's get to the next one. That one didn't go over very well. It was too much. It was too much like comments and not enough like black letter law. So we ratcheted it back considerably. And then we put all the definitions in one section. Because in most restatements, according to the ALI Illuminati, and to the membership, definitions are usually just contained in one section. So you see Indians here, and we're back to where we started. Remember that effort I made to we updated the borders to put more detail in there? And you might go back to that part. Now, you see that. This is the next effort after that. We went back to being circular, so they said, no, you got to have something more to that. So we did. And we don't have to go into that. This is another effort, and this is actually approved by the Illuminati. We took it to the Illuminati, the ALI Council, and they said, yeah, it's like the 4th time you've been here, yeah, that's fine. Just stop. And So we did, but the approval process, you go to the advisors, the super intelligent, specialized people who are true experts in the field, people like Reed Chambers, I already mentioned some other people. And then they help you, those discussions are really just incredible. I mean, we read argued cases in the Supreme Court, worked in DC for many, many years, still does. Just an incredible wealth of experience. And you have people like Ed Niebler, same kind of situations, argue over 100 cases in the Supreme Court, knows the federal government's position on any law and knows many of the cases because he argued them as well. You know, and then you have people from the agencies like Ines Prince, when she was Interior Solicitor's Office, and still is part of the project. People who are the academics who have delved deep into the history of these issues, read all the cases. This is an incredible discussion. And then you take it, all you do is you just give their comments. They actually have no approval authority. In order for a provision in your restatement project to be sort of the law of the American Law Institute, to be positioned for the ALI, and therefore subject and entitled to great weight, you have to get two approvals, the ALI Council, the Illuminati, and also the ALI General Membership. And every year the General Membership meets, and there's, like I said, upwards of 4,000 people at any given moment in the room. Sort of like a tribal general council, you may have 200, 400,000 people, whatever it may be, at the annual meeting. So this got past the ALI Council. And they made some suggestions, some recommendations on cleaning it up a little bit, and that's totally fine. Again, the ALI Council, their generalists, there's a lot of big names in law there. I mean, DC Circuit judges, 7th Circuit judges there, law professors at schools that don't know my name, like Penn and Harvard. They're on that meeting. They're also, it is the Illuminati of the law. So you get past them, they get to go to the ALI membership. And that group of people, again, 1/3 practitioners, 1/3 judges, 1/3 academics. That's a much bigger room than a law room, usually in a hotel room in places like DC or San Francisco, and anybody can raise a question. And there's a process, a formalized process. Somebody will stand up and say, my favorite of all time, frankly, is Fletcher, Washington, D.C. And so he asked the question, this is a very rote thing, he was just curious about provision, when it came from, and I was able to answer the question. I looked him up later, that's William Webster, the guy who was the director of the CIA. Probably can't leave the country because he'll be extradited. He's war criminal. Anyway, so, it's surreal. You'll see state judges, federal judges, they'll stand up, people who are really trusted and asking really interesting questions. So if you did a vote there, and you had it already approved by the council last month, this is what we ended up with. We started with circular definition, and we ended with somewhat circular definition. But we went through virtually every single incarnation of what is an Indian that you possibly could have. We fought tooth and nail for what should be included in this. I don't want to know how many hours we spent discussing whether to include the word member or citizen. And ultimately, we just went with member or citizen. But I assure you, there are people in the ALI who are irritated as hell by that. It should be one or the other, not both. And then there are people who like, it can't be citizen, because you know why? Indian tribes are not really sovereign. You can be a member of a tribe. And most tribes actually use the phrase or term member. And then there are the people who are, you can't say member because Indian tribes are citizens, are states, are nations. And nobody's a member of the United States or a nation. They're a citizen. So, anyway, it's frustrating. We do our best. We fought here. So, thank you, Jennifer, for your great help. So, just to give you a sense of where we are, this is section 1 from chapter 1. Chapter 1 is about federal government. It has a few definitions in there. Section 2 is what is an Indian tribe. That's actually much easier to define. So chapter 1, the first 8 or 10 sections or so, is about the powers of the federal government. It has stuff in there about the trust relationship, has stuff in there about commerce clause, all that good stuff. Chapter 2 is about the powers of Indian tribes and how federal statutes can ratchet up and down federal sides and things like that. Chapter 3 is about the powers of states in relation to Indian tribes. There's also a subchapter in there about the Indian Child Welfare Act, and enforcement of tribal court judgments, that sort of thing. Chapter 4, Kate Smith really took lead on this one. He's more of a transactional lawyer than I am, or went on this transactional lawyer too. But is about economic development. And ALI was particularly interested in how tribes interact economically. So we're plowing through all of that good stuff. The ability of tribes to regulate on reservation economic activity, and also tribes as economic actors. Chapter 5 is tribal criminal jurisdiction. We're still fairly early on. We have a full draft of that. We're going to try to get it approved here in 2 weeks on that question. And, chapter 6 is we haven't even really begun. Maybe that's the next draft. That's natural resources, treaty rights, water rights, all that good stuff. So there are a few things we probably want to know, like where really hot controversies were. Who is an Indian, or what is an Indian, is not what is hot in the controversy, but nobody, in the end, they were just more interested in clarity. There are hot controversies. I think the one that has possibly frustrated me personally the most is the question of the phraseology of the restatement. Every time we do a draft, I have to go through and cut the phrase trust obligation, or trust duty, or trust responsibility, because the federal government attorneys, particularly Ed Beaver, and also a few others, even Judge Candy, will say that there is no such thing as a trust obligation, a trust duty, or a trust responsibility, because those 3 words denote enforceability. The trust relationship cannot be enforced against the federal government. From the Department of Justice's point of view, it can't be enforced ever. I mean, they will fight tooth and nail on this issue and do not want anything about an enforceable trust responsibility, relationship, or trust duty, or whatever, in this restatement. And it's dramatic. The things that certain people will do to try to stop the approval of this kind of language. It's nasty. So we use the trust relationship. And there are 2 key sections in the restatement that deal with trust. One we have approved. It's about the general trust relationship. And what that means is, we got the DOJ very happy with us on this one. The trust relationship is that relationship between the United States and Indian tribes that originated with treaties, the duty of protection, and also can come into play through the federal recognition process. The United States agrees through administrative or legislative recognition process to take Indian tribes who don't have a trust treaty relationship with Indian tribes under the United States Treaty of Protection. That is actually a source, a robust source of congressional power. What we need. The Department of Justice loves it when we emphasize the sources of congressional power or Indian affairs. In fact, I keep reading on Ed Beaver. He's hilarious in one way, and then he says there's never a way to enforce. You can't sue the United States government. He's not going to let that happen. That's his job, is to reject that. But if I'm going to make up some crazy constitutional argument in which Congress has the power to do something in Indian affairs, he's all power passed. It's great. So that's one that's approved. This general trust relationship that just says, when Congress chooses to, you can't make it do it. Remember, it's unenforceable. But when Congress chooses to, it has robust power to deal in Indian affairs, to legislate in Indian affairs, same with the executive branch. Now, the other part, which has been pending, and I can put it section 10 up here, it's the albatross on my back. It's the one that says if the United States has a trust duty and you sue for money damages, that's the one that people are really interested in. And you have people like B. Chambers who have litigated Supreme Court cases in which tribes have prevailed and won money damages against the United States. And you have people like at Fletcher who have litigated and won Supreme Court cases in which the Supreme Court rejected money damages for Indian tribes. And the kinds of things that the Supreme Court allows tribes to sue for money damages are so indistinguishable from the cases in which they say no. They're so difficult to parse out an actual principle that you put in black letter law. And we've been, fighting is not the correct term, it's spirited democratic thinking. spirited intellectual debate. But I've given up on section 10. I've actually created a subsection of people, about 4 or 5 people. They're all dudes. They're all dudes. And they hash it out. Every 6 months or so, they have a conference call, and they go through the draft, and they argue about a couple of words here and there, and then they agree that 6 months to meet again and do the thing all over again. And I appreciate that they keep doing it. I hope they come up with a consensus one day, and they come back to me, and we can take it to, as reporters, and take it to the Illuminati and the membership, and get this thing done. Because it is true, there are times when tariff can sue the United States and win on the damages. It's happened. But the interests at play are really, really contested. So that's just one example of a truly hot topic. I've spoken for about 20 minutes, and I don't want to lecture you to understatement. There's a lot of really interesting things that go on, but they're interesting maybe to me, but not necessarily to you. So what I'd like to do now is, if you are interested, I hope you are, is ask me some questions, anything about the process and about the substance. I'm happy to discuss as much as I possibly can. Looks like we got a question from Alex.
So my question is this: what happens when at the Supreme Court the law changes? Like, so for instance, the trust duties, that Ikaria decision, I think, was added substantial negative level of trust responsibility. Do you have to go back all the way down back to step 1?
No, that's a really good question. So the fact that we're doing an Indian law statement has actually been sort of an existential crisis for the American Law Institute. The origins of the restatement projects were to take common law, the law that judges are making, usually state law, that's uncodified, and the courts are all over the place. They collected all of the major arguments, put them together in one project, and then identified black letter what should be the proper rule. Now, so there's that issue of common law. Indian law really isn't common law. It's almost all derived from some statute. Now, the statutes, the constitutional provisions tend to be vague and ambiguous, so there's plenty of what you could call common law that comes out of the interpretation of that. And the other thing that, and that's something that ALI has been going into over the last decade or so, is getting into doing restatement projects on laws that come out of statutes, like employment law, right? Mostly statutory law at this point, with a bunch of common law mixed in. But so long as we can show that there are statutes that tend to have lots of opportunity for judicial interpretation, they're fine with it. It looks like common law, they can make that satisfactory. Constitutional law is a much trickier question than mere statutory interpretation because, first of all, there's only one court, really, that engages in the constitutional analysis that anybody cares about. I mean, federal and appellate court opinions are important and add a critical flavor to these decisions, but ultimately it's the only one court. There are no splits in authority for the Supreme Court, unless they disagree with themselves, and that's not possible. We can't acknowledge that even if it's true. So yeah, they can change things dramatically. So there's a section in the very last draft we put in on the Child Welfare Act, effectively the section 1 of that is constitutional. Well, as of yesterday, in Texas anyway, it's not, right? So they're not going to approve that section, or maybe even any of it, until that litigation is settled, until the Supreme Court affirmatively says, I mean, that's possible, I have no idea what the scope is going to be on that. It's very possible. The way we get around something more into the Hickory case. Hickory, for those of you who don't know, is a case that parsed through a little bit of the general trust responsibility or relationship, I should say, that Indian tribes have in the United States, but a little bit of flavor around the enforceability question. And so there's a rule of thumb that nobody likes to admit when it comes to restatement. The rule of thumb is everything's correct on a certain level of generality, right? So if we see something kind of specific in one of the comments, and then the Supreme Court says that will correct wrong, we can just stuff that off and say, there's still principles within the Hickory case itself, which for tribal interests was really quite disastrous. There's a whole bunch of that stuff in there that's really quite helpful, and it reaffirms that there is a general trust responsibility relationship. You know what also makes me irritated by this is the Supreme Court says trust duty, trust obligations, trust responsibility, sometimes trust relationship too, but we're not allowed to actually use that phraseology in our statement, or we will be pitchforks and torches will come out. But yeah, that's, I mean, in a vague way. And a level of generality, that's how we deal with those cases. You'd be surprised how few cases really have go to the black letter. There's tons of black letter degree itself that really isn't a mistake. You know, one quote or another. Yeah.
So I was curious from your conversations with the Illuminati and people in the sort of general legal community, both what your sense is of sort of knowledge of Indian law in the general legal community, and then perceptions of Indian law by people who are non-specialists.
So I'll tackle the great question. I'll tackle this on two different angles. First is the American Law Institute historically is this staid white male, elderly white male group, right? And over the last couple of decades, not really even that long, they've been making a concerted effort to try to diversify, add women, add people of color, add younger people. So that's part of all this. And the fact that they had an Indian Law Project is part of that, right? I mean, they could have stuck to, we're just going to do, you know, it's surreal to see a group that a good third of them are truly diverse in terms of age and experience. And then the rest are still the guys who don't die and show up for all these meetings, arguing about sexual assault on campus, right? And you know how those lines play out, right? You can see it happening, and it's a weird thing. Now, in Indian law, this is both the plus and minus for us. The plus is, remember I said in the ALI general meeting, if you could have a room with 1,200 chairs in there, and maybe only 200 or 300 of them are filled at a time, that's the voting forum at that time. We did that with Indian law. Nobody, very few, relatively speaking, come. When it's sexual assault on campus, it's packed, standing room only. But when it's Indian law, it's like, this group right here, spread out over an entire hall. So it looks, there's a good number, and it's a robust and spirited discussion, and intelligent discussion, but way fewer people show up to that sort of thing, which is a benefit to us at the ALI general membership, because there's nobody there to galvanize like opposition to it. And I don't think we've done anything that would is out there. So the institute itself is really dedicated toward projects like ours. The culture of the ALI is still, and may always be in a sort of a transition, and that the interest within the membership itself are interesting. The ALI Council is somewhat similar. I mean, they all have to show up. I mean, they're paid pretty well to show up. The 40 or so of them, they're always there. And many of them are people who are writing Supreme Court cases. You know, like Seth Waxman is there, right? And Patty Miller. And it was a part of their practice. And so they're very close to it. There are others who don't get a lot of Indian law. They ask the kind of questions where they're just making sure that this is rigorously vetted enough so that it's good enough for the ALI. There are others who just ask questions like, I didn't know this, right? Very interesting questions. So it's interesting. Yes.
Sorry, I forgot our special handshake as a member of the Illuminati. So one of the interesting challenges, and this comes really late, we think about the restatement of torts, the restatement of contracts, and it was just kind of, that's what we did. There was this thing called law out there, and then we updated over time. This kind of picks up on Alex's observation. how tricky is it to, the fiction of the restatement is that it's a snapshot of kind of this everlasting black letter law. What's the role of history in these discussions, which plays such an important role in Indian law, but generally doesn't play as much of a role in the restatement process because of this fiction that it is just the eternal law?
You know, that's part of, let's talk more about that. I think that's really critical. So, within the ALI different projects, there are restatement projects that are really described. There's also something called principles projects, and those are parts of the law that the ALI thinks are just way too dynamic to actually be able to set out. Maybe they're too new, there's not enough judicial pronouncements on them, or something like international law. So aspects of international law, for example, are just too up in the air. So what you do is you hire people like us to be reporters, but for a principal project, and that's more like a legal treatise. You can just say what you want, you know. And the ALI just likes having product come out. They really like to have more product. They like to have this discussion. They like to be a part of this development of this law. But they also know that it's as a principles project, it doesn't have the same rigor or oomph that a statement does, right? So at the very beginning, the first comments we received were, should this be a restatement project or a principles project? And as reporters, we want to do a restatement because that's the thing that is, as you say, it really is more for posterity, right? It's really more influential. But we let the council make that decision. And I don't really know, that was years ago, 2012, when they made that decision. And they stopped with it since then. I think it's gotten to the point where I think they're pretty satisfied. The first couple of years, a lot of our comments from the individual members and the ALI people were, this doesn't seem like a restatement project. We can't figure out what the Indian is, right? But we started to nail it down a little bit. And part of it is really critical. And I use the metaphor, I took this from Poor White Horse North or something, the metaphor of the low-hanging fruit, right? So there are some things in Indian law that are timeless. They go all the way back way into the 19th century. And we really go back to those foundational principles. And if we only took stuff to that stuff, though, we don't have like 4 sections. And we're over at 100 now. So there are some things that we're over a little bit worried about. Right? One of the guiding principles of the ALI, and this was true when Herbert, there's a quote on the ALI building in a room like this where we have to meet, Herbert Wexler, and it basically says, look, you know, not everybody agrees on everything in law, but we're the ALI, and we can decide or make strong recommendations as to what the law should be. So there's the descriptive part of our function, and then there's a little bit of the normative part. And they like to tone that down a little bit. But when it's Carl Llewellyn and Herbert Wexler are saying that the normative part is nobody's going to argue those guys, right? So we have a little play when it comes to the normative stuff, but not much at all. Because I'm not Herbert Wexler, and she's not Carl Llewellyn. And they remind us of that pretty regularly. And they also remind us, and Alice's point is really important, the Supreme Court could come and change something dramatic. So the wonderful part about all this, structurally and institutionally at the ALI, like I said, really, they're striving for product and for influence. The ALI director, the administration, the people who brought us on board and organized everything, they were the ones they're not the council, they're the ones who bring the council together and membership. Strong supporters of this. And they say, look, we know that the Supreme Court could come and change something, and so what? So then we'll do, 20 years from now, we'll do a Miller's Gate project and acknowledge that that's the case. And they're happy with that situation, I think. And so, and the other part of this is a little bit of power politics that's beneficial toward having a mistake project. There are all these judges that show up at all of our meetings. And they usually don't say a whole lot. And we know judges, they're wary of putting positions down. I mean, the greatest thing that judges do when they do show up and say, that's the next section, I can't understand it, I would never cite to it. And oh, yeah, we could rewrite it. Of course. But one of the great things that judges do, judges like Dan Wood, Harry Millett, Lily Fletcher of the Ninth Circuit, Schroeder, all these great people show up, and they tell us when they can't do something, but more importantly, they say, we desperately need this project. They love that the project exists, and they want to have it. In fact, I think the guy who works right here in the project is a third circuit judge, who was a leader in the leadership structure at LI 20 years ago, who just hammered on them when we didn't have an Indian law project. And it took them 10 years to get around to organizing one. But it was the third circuit that did many cases. So the judges are our best friends. That's like my favorite interactions with the judges. They're terrifying, but I love them. Yes.
How would you compare or contrast the ALI product to the People's Code of Conduct?
Thank you so much for asking that question. The question is, how does the, I don't know, I will flavor to it. How does the restatement live in a world where you already have Andy's nutshell and the common handbook on federal union law? Well, here, the most superficial distinction between them is, there's also the Conference of Western Attorneys General test book, right? Yeah. So I actually wanted to answer this question, and not picking on Mona here, she's like, are you sure you want to do this? I invited the Common people and the Conference of Western Attorney General people to Michigan State, because they both had come out with a new book by 2012, right as we were starting, just to see their interaction with each other. And they were brutally honest. I mean, it was very simple, it was awesome. They were brutally honest. Mel Newton, Bethany Berger from the Common people came out and said, look, you know, we're all professors. We tend to be exclusively are supportive of tribal interests. And they might debate over specific numbers of that, but that's their true bias. And then the guy from what I call CWAGs, I don't think I'd like to use that as an acronym. I can't remember his name, but starts with C. He's a good guy. And he's like, yeah, well, we pretend for like a decade that we're totally neutral because we're just attorney general. Yeah, we're states' rights all the way. And he just came right out and said it. So you got tribes on one hand, states on one hand. I don't know who's ready for the federal government side. But so we kind of sit in the middle. And where I think the big difference for us is our advisors come from, we have lots, they insisted, and I totally agree, to get as many state people on board, state and also federal people who are more neutral, I guess you could say, in between tribes and states. So we got people like state court judges, Carol Byer from Kansas on there, McAllister, I can't remember his name. Rich McAllister, he's like he's Solicitor General for state of Kansas, who had argued a bunch of cases on behalf of states' rights, and I think he's the U.S. Attorney in Kansas. Tom Getty, Lynn Slade, people that represent states and also private interests, often in opposition to tribes, and we have their views on all of this stuff. And they're really, that's not something that happens. There's a lot of great intellectual digestion of all these ideas when we get these groups together, and they pass ideas back and forth, and you'd be surprised how maybe you'd be surprised. You'd be absolutely surprised at how much we could coalesce around positions with everybody in the room. And then again, I have to emphasize the importance of the judges. That we have judges on the more progressive side and judges on the more conservative side, or whatever. But the biggest impact is keeping us, everyone, both all sides, honest and saying this isn't something that we could use, or it's pretty apparent this isn't done yet. You need to keep working on it. And those judges are absolutely critical. And that's the difference, the big difference between us, our project, and those treatises. And those treatises there's nothing that needs to come in handbook if you want. So there's a reason why almost every major Indian law case cites to it repeatedly, because it is the go-to source. And even the CWAG would admit that. But what they're missing, to some extent, is the analysis. And I think they would admit this. Do they don't judge? I think it's because they don't judge us on this subject. The judges they're doing their own thing, right? But we have to. Mr. Compton.
So how much does tribal law figure into this? And actually state law too, but I wonder, is it predominantly federal, or do you have a about the segment of tribal laws?
So that's a great question. And this was one of my favorite quotes. I hated it at the time, I didn't. I still kind of do. And Judge Candy said, you can't talk about tribal law. Because there's now, I'm computing this is years ago, he said this. There's 573 federally recognized Indian tribes. That's 573 tribal justice systems that are all completely unique, even though they're typically the same. You can't, that's 573 statements. I'm like, okay, we won't talk all the time. But there's a lot of stuff in there about, chapter 2 is full of the powers of Indian tribes. And we modeled that on Felix Cohen's memorandum after 1934, powers of Indian tribes. And so that's all federal. So it's a bunch of federal statutes, but the federal statutes are cases. So when Felix Cohen was writing in 1934, he said, here are the powers of Indian tribes. And that was a politically important moment because it was right after the IRA was passed. And Wheeler and Howard, who were the senators who sponsored the thing, were actually immediately trying to get it repealed. So part of the response to that was to push back and say, here are the powers of Indian tribes, and don't be so scared. There's a lot of authority behind it. They're not doing things that are terrifying, right? So just leave it alone. So we took that memorandum as a basis, and going forward, we basically adopted the, later on, Cohen in the handbook wrote that Indian tribes have all the powers of sovereigns that they haven't personally relinquished or haven't been divested by an act of Congress. So we got that Cohen formulation, ingrained in the, codified in the restatement, and went from there. So it is, the power of Indian tribes really is about the federal government's acknowledgement of what our tribes have, but the inherent powers of tribes, many tribe powers have not yet been exercised often, or even discovered, whatever this might be. And we did everything we could in chapter 2 to make sure that that list of powers is not the limit. And the other thing I did in the reporter's notes, which I talk about reporter's notes, I just threw a bunch of cases in there to get a sense so that when state and federal judges read their statement, they see the black letter and they see a description in the comments. And then when they go and look, the reporter's notes are basically the footnotes to these things. So if you're a law review article, writing a law review article, and you have footnotes, the reporter's notes are footnotes. And we have pretty much significant control over what the reporter's notes. I can say whatever we want, obviously, and the reporter's notes. And I do. And I read a lot of them, and they all tend to be tiny, and so none of these old guys can read them. And I read a bunch of stuff past them. But that's called tribal law. But the restatement itself really is almost exclusively federal. And that's and Judge Candy in particular, has really pushed back on whether or not it should be restated, right? And the question, for example, when the Supreme Court looks at cases, is when the Supreme Court in Martinez said, well, tribes have the power to determine their own membership and inheritance rules and some other things. And then a few years later, the court in Montana says, well, here's what the power of tribes are: inheritance and membership. And that's it. They have no other powers. And we want to make sure that, it's a logic fallacy, of course. We want to make sure that the logic fallacy is not codified effectively in the state. But yeah, it is mostly federal. And that's a serious limitation.
So what are your thoughts about doing a tribal restatement, a restatement of tribal law? Because that is a pretty daunting task, but that would be a huge, that'd be great.
It is the rule in perpetuity.
It's Miranda. So here, this is just me personally. I think it should be done. And you know that I did a restatement of the law of fair trial ban, right? And then Little Trash did one 2 or 3 years later. This is like 100 cases.
Don't you need to survey a tribal law?
My goal, I don't know if it'll come past when this project is over, hopefully just in a few years, hopefully. I want to do one, I have a whole outline for an Anishinaabe jurisprudence treatise. And it's just, I'm going to start with Michigan tribes, maybe expand it out to some of the Wisconsin and Minnesota, the Anishinaabe tribes. I'm not going to, not all of them do their own thing, or Greek or whoever, I can't deal with that. But I think that it should be done. Again, anything can be done. Yes, Al?
I've been teaching torts for 30 years, and understand that, the restatement of torts is extremely important because each state Supreme Court is going to adopt a section or not, and then it becomes the law in that state,
Yeah.
the Supreme Court. But like, I'm trying to figure out how your restatement will be used. And a lot, except for Indian Child Welfare Act, a lot of the stuff is federal. So do you have a vision about, how influential it can be within the federal system?
No. I was just trying to finish it. That's a really good question. We occasionally, right at the beginning, people were asking that question. And I think the number one driver, not to be cynical or even to undermine the project, really is ALI is trying to be relevant as much as it can. I do think that it has the ALI itself and the statement project within the ALI has a lot of oomph, for lack of a better word, I'm going to grade that obviously. And it's going to mean something. It's going to be, it's intimidating. You don't want to handle it this thick, right? And even a sea leg is huge. And Coach Candy's nutshell for all of it, it's still a nutshell, tiny. So there's nothing really in between. So I don't know. There are a lot of federal judges who, this is what they tell me, I don't know if it's exactly the case. A lot of federal judges really are just completely confused, not confused, clueless. They don't know where to begin when they get into any law question. Even the ones that have seen a lot of cases, judges that the true generalists, so they get it. And once in a while they get into a law question they haven't seen before, and it's maybe they don't want to go to the one hand or the sea leg, but they got to go to the statement. I don't know the answer to the question any better. I don't know how it's going to be used.
Yeah, no, but I'm thinking, like, perhaps, if a circuit comes out, they'll basically say, okay, we are adopting the federal circuit, this section of the restatement, and then it becomes the law during that circuit. So it could fundamentally change the way we view Indian law as far as precedent.
I did have more of a view. Remember I told you about Herbert Wexler, like we need there's 13 federal circuits. What if you have 3 circuits that say the rules should be this, 2 circuits that say this, like say statutes of general applicability, federal statutes of general applicability, there's a circuit for it. The 10 circuits basically alone and everything else. But we could say, look, we have this circuit split, let's get the better rule, right? And so you missed that a few times, and we went down with Juniper. So it's not the same. They say it's too much constitutional law for it to be like that, because ultimately the Supreme Court's going to decide. It would be interesting, because there are places where we could say that, and we try to do that. Like, for example, we had a great debate and discussion and thought. In fact, the Council approved it over very heated rhetoric from federal government attorneys. The question of whether the Indian canon of statutory construction trumps Chevron deference, right? So we had a discussion about that, and we had it at the advisory committee. And people like Angela Riley and Kristen Parker were saying things like, the Indian canon is constitutionalized. It comes from the 19th century. And robust argument. And in the government side, Ed Diebler basically said, no, Chevron things. Chevron deference, the agency deference. And then, they only get in trouble when he says things like, well, Indians are basically just aliens, so they don't, the personal federal, and then we have to take a break, because they're really mad then. So I thought we had a strong argument. And actually had Seth Waxman on my side, because he came up to me and he said, look, I just litigated cases in the Ninth Circuit. And in the Ninth Circuit, Chevron needs to be in canon over every time. But in the D Circuit, the canon needs Chevron. So I got a case, part of my case, I refiled it in DC, and I got one there, and then I went back to the Ninth Circuit, and one there too. I was like, see, Seth, we can do this. And he's like, no, whatever I need says you have to do that. I was like, that's the off the record, here I am on videotape. Let's be great. There are times when you're in a room with the ALA membership and there's a question and somebody raises their hand, and if the then that name that raises their hand and says, I think it should be this, that person might be the one in the day because of who they are, regardless of the merits or what any of the merits are. That does, on occasion, and usually in Merrill's circumstances, have created. And yeah, it could be, Reed Chambers, it could be short guy, or Kevin Warren. Yeah, question in the back?
Can you say, is there a particular chapter on jurisdiction, or how does?
It's all over the place. We got a jurisdiction you want to talk about? Legislative jurisdiction, tribal court jurisdiction? The whole thing is jurisdiction.
Criminal civil jurisdiction, whether you have tribal courts or states?
Yeah, chapter 5 is criminal jurisdiction, so we have 10 or 15 sections in chapter 5 that deal with mostly federal criminal jurisdiction. There's stuff in there about states too. Do you know that chart that Harlan Dickinson put together in Oklahoma, the U.S. Attorney chart for federal criminal, Canadian country criminal jurisdiction? We put that in their statement. It literally is in there, and then we wrote it out as black letter. They were all laughing at me for doing that, and I did lots of cross references. The civil court jurisdiction is mostly in chapter 2, power of Indian tribes, so we have stuff in there like there's a section on Montana rule, there's a section on tribal court exhaustion, sections in chapter 2 and 3, which is mostly about states, about enforcement of tribal and state court and federal court orders in foreign courts and each other's borders. So yeah, chapter 2 is mostly about tribal powers, chapter 3 is mostly about state power. We had a great section that I put together that I was really proud of on tribal official immunity until the Supreme Court granted cert in Lewis versus Clark, and I had to throw the whole thing out. And I still weep because it was perfect. It was perfect because nobody else had read it but me, and it was good. You know,
So I think we have time for one more, and then we will break for lunch.
Yes.
On your definition of Indian, did you take into consideration the tribal nations that did not enter into negotiating status, and then also the tribal nations that have membership? I'm Blackfeet. I have a lot of my relatives are on the Canadian side because 60% of our bands are on the Alberta side of the Canadian border. And then also Papago, I don't know them.
Okay.
Their reservation is on the Mexican border, and most of their tribal membership is in Mexico.
Sorry. So, really great question, and I'm surprised you put on something. Yes, we did have serious discussion about the Indian people who are not members or citizens of federally recognized tribes, and we dealt with some of that in the Indian country criminal jurisdiction because, as the previous panel mentioned, you can actually be an Indian without being a tribal citizen somewhere for purposes of criminal jurisdiction, but not for purposes of civil jurisdiction. And so the thing that guides any project within the ALI and restatement project, there has to be cases that back you up. So whenever somebody asks us a question, why didn't you do this? Or I think you should do this, we always very quietly say, we couldn't find any cases to support that proposition. If you have them, please send them our way. We will definitely take them into consideration. And for our purposes, sadly, unfortunately, there was nothing we could do about, I think, helpful towards people of Indian tribes, like the tribes that are not recognized by the federal government. We just couldn't find cases that would be enough to create black letter law. And we got asked about that, and emotionally asked about it. There are people who are no longer part of the project who don't show up to meetings anymore, I think in part because of that. And it's sad, unfortunate. But I don't know what to do in this limited context for that. There are tribes in Michigan, I have friends who are members of the tribes that aren't federally recognized treaty tribes too. And I don't know what to do, at least in this one, but other things do. Now, it's much easier for the still difficult, much easier for our project purposes when it comes to something like the Akwesasne, Amamatham, the tribes, Garden River and Sault Ste. Marie in Michigan, that are split by the borders. Because the federal government does have laws, and there are cases that support the extension of services in some places to them. But there are some things that are still in the air that we can't touch. Border crossings is something that we wouldn't touch because there's just not enough law that has, it's too dynamic. The question has been settled. We're looking for settled law. And there's nothing settled on that. So, at least not yet. But thank you for that question. It's important.
All right, well, thank you. Mr. Fletcher, if you want to see more.